afternoon to our distinguished guests, e-delegates. Thank you for joining us on this webinar. Muhammadu Buhari to the Cam bill as the icing on the NBA SBL cake. And I really meant it when I said that. It's been a very long road, and it's very apropos that we have with us today some of the key drivers who labored tirelessly to get the bill into the end zone using American football metaphor. Namely, I'll start with the beneficiary, or perhaps the most the entity, the institution that would benefit the most from the regulatory perspective, which is the Corporate Affairs Commission. And we have with us this afternoon, Alhaji A.G. Abubakar, who's the Registrar General. Good afternoon, Alhaji Abubakar. Thank you for joining us. We also have, yes, we also have Dr. Jumoke Oduwole, who's the Executive Secretary of the Ease of Doing Business Secretariat in the Presidency. She'll be joining us momentarily. She's the executive. Oh, I didn't realize. Oh, thank you. Thank you so much. Dr. Oduwole, thank you so much. It's a delight to have you on the program. Yes, thank you so much. We have with us also my good friend and brother, Inna Ude, who's a fellow at the NESG, Nigerian Economic Summit Group. Also on the panel, on a distinguished panel, we have our scholastic colleagues, Mrs. Ozofu Ogebudia and Mrs. Tony Bashir. Well, my brother, Mr. Ibi Jemide, is going to be the moderator. He's the vice chairman of the Nigerian Bar Association section of business law. I'll just say a few words very quickly. That in my own humble estimation, the act is already doing what was intended, or what is intended. Specifically two things. One is to ease doing business in Nigeria, and secondly, to make the Nigerian economy more competitive. Recently, I have to admit, I've seen certain comments on the media, social media, from certain quarters regarding perhaps that the act is not perfect. I'm not sure that you can ever have a perfect piece of legislation. But first, my response would be that first, the act is already doing what was intended. And secondly, for those who have any issues with the act as it is, they are welcome and indeed encouraged to perhaps coalesce and perhaps prepare a compendium of proposed amendments, if you will, that could be submitted to the National Assembly. And dare I say that to the extent they require us, when I say us, many of us who are on this webinar, to join hands with them, we'll be happy to do that towards any proposed amendments that we believe and we subscribe to as being those that would further advance the main objectives of the statute. I cannot thank enough Dr. Jumoke Oduwole. We've worked collaboratively on a number of matters. The Cama is one of them. There's another one that we're working on currently, the Omnibus Bill. That'll be a topic for another day, but I'm just give a shout out to that right now. Likewise, with the NESG, Mr. Nana Ude, and his CEO, Mr. Dayola. The RG, I'm sure many of you who are on the program today would have seen that he's been on numerous programs with the SBL, he's a member of our council, but he's been a tremendous supporter for trying to help transform the Nigerian economy and generally make things easier for business owners, particularly the micro, small, and medium enterprises. I would be remiss if I don't acknowledge my colleagues, Ozofu Ogebudia, who worked tirelessly as the scrivener with respect to the drafting the bill that was submitted together with Mrs. Toyin Bashir. Toyin actually struggled between working at the PEBEC office, and also she's a partner at the law firm Bawa and Godalo. So it's been a labor of love by everyone. There are many others that I'm unable to mention today, but I wanted to just give that acknowledgement to those of us who are here today. So with that, I will hand over to my very able friend, Mr. Ibijemi, to take it away. Thank you very much.
Thank you, Chair. Very well said, as usual. And thank you, everybody. I see we have 988 people logged on. This shows how important this is to people. And I'm sure many other people will log on by YouTube after we get 1,000 people on board the Zoom call. So without much ado, we will start, and we will throw questions around to the panelists. We are very grateful that they could attend. And then after that, we will take questions from the participants. As we go along, I urge you to type in your questions in the chat group. Ayoyinka Wasedo is there to get all these questions, and we'll take them at the appropriate time. So just type in your questions as they occur to you as the panelists speak. If you have a question, just type it in immediately. Thank you very much again for attending. I think let's just start by asking each of the panelists one major thing that you are happy about concerning this law, one major provision that makes you really happy. And I can just throw one out there quickly. I'm really very happy that a company can now have one shareholder. So if you don't, if you don't have to look for somebody to join you, you can start your own company by yourself. I think for me that's one major thing that that I'm happy about. So I will start with the RG. What makes you happy, sir? One thing.
I will say everything about the law.
Tell me the one that really makes you very happy.
I wouldn't want my colleagues to say I'm opposing lawyers. The issue of statutory declaration, at least the owners of these companies or the first directors now have the option to do statement of compliance. So lawyers can still be engaged by those that can afford to do so. But those that cannot afford to engage the services of professionals can register their own companies directly. So this is one issue that I really like about the new law. Thank you.
Thank you. Dr. Duwale, one thing.
It is very tricky, but I think I'll have to go with the options for electronic meetings, electronic transfer of shares, virtual AGMs. It's more than one, but it's still under one thing.
It's all virtual. Everything that has gone virtual, you are happy about.
Yes.
Yes.
Particularly happy about electronic signatures, tendering evidence of electronic, same as original. Yeah.
Excellent. Nana,
yeah, I'll go with you. Single shareholder limited liability companies.
It seems as if you've been wanting to set up that single shareholder company.
Yeah, because it will definitely unlock the power of innovation and enterprise from a number of our young people.
I totally agree with you.
And I'm going to speak more about it when we start the conversation.
Excellent. I totally agree with you. Toyin Bashir?
So for me, I guess it would be, and I guess there are a lot of things under that bucket, I mean, that particular bucket, it would be, all the exemptions, first the definition or redefinition of small companies to allow quite a number of businesses to qualify as being a small company, just because, I've come to realize that indeed it is one economy. So if we have the small businesses thriving, then I believe we all stand to benefit from it. So it will be the exemptions for the small companies.
Thank you. Ozofu Gemuda?
I was here hoping that by the time it got to my turn, I would have selected one. I think I have three,
Okay,
but
okay, give us two. Give us two if you must.
I have to say the reduction in the cost of registering security is going to have such an impact in unlocking value to companies that take credit and not having to deploy a significant portion of that credit on regulatory costs. That's one. I think the second one is company rescue and just how it's going to open up that field of practice. So I think that also that creates a door for lawyers that feel the CAC has taken something away from them in terms of filing. They can choose to make that their area of specialty and just put that space.
Yeah. So I mean, what you're saying is it costs much less now to borrow money, because when all the filings are done at CAC, eventually it's the customer that pays.
Yes, exactly.
So I mean, we should see more people going to the bank to borrow money at less cost.
Hopefully.
I think that's a good one. Okay, so let's go back to the RG, the Registrar General. We'll start from you, sir. You know, you're the hub. You are the hub around which a lot of these things will.
The by the side, we are together. So she's part of this too.
RG, people are not sure about the transition provisions, the effective date. You know, when do we start? You know, when can Nana register this, his one shareholder company that he's wanted to register? Can he file today? You know, what are the things that will happen over the next couple of weeks? You know, what's going on? You know, because every time there's a new law, you know, we have to know what the transition provisions are. So, you know, can you just brief us on that?
Thank you. Thank you so much, Chair, for that question. You know, by the provisions of the Authentication Act, the National Assembly has to gazette the 2020 Act. And that process is ongoing. Only yesterday, I had to seek the intervention of Dr. Oduole to facilitate the process. So the Act is supposed to come into effect immediately because there is actually no transition with respect to the new provisions. The only transition may relate to issue of share capital issued and authorized. But other provisions are supposed to come into effect immediately. But that can only happen after the gazetting. And on our own part as an organization, we also have to tweak our own technological device, the application, to allow for some of these changes. For the new legal entities like LLP and LP, that may not be immediate because you need an end-to-end electronic solution to do that. But for one-man company, issues of statement of compliance and other matters relating to new registration, I think that can happen as soon as the law is gazetted. So this is my answer to the question. Thank you.
Thank you, RG. I know you're not fully in control, but if you were to hazard a guess, you know, maybe Dr. Oduole too can step in here, you know, if you were to hazard a guess, just an informed guess, you know, when would you say this law will be gazetted and people will be ready to, you know, to implement the law?
Hopefully by the beginning of October, hopefully. We want to see if we can get this accomplished between now and the end of September, so that latest by 1st October, this law should be in place. The implementation can start. Yes.
Okay. Dr. Oduole, are you agreeing with that?
Is rightly conservative. Of course, we're going to push for much quicker. Only yesterday, we were engaging, as he said, with the leadership of the National Assembly, and they are also eager. So it's basically back to them, but we've been working excellently well together on this. So 1st of October is very conservative and rightly so, RG. We will definitely, we're committed to making it happen even quicker if we can. But that is a rightly conservative guesstimate.
Yeah. Well, thank you very much, Dr. Oduole. You know, I think this is very important because, you know, at this point in time, there are transactions going on. People find themselves midstream. People have drafted documents. They're thinking, oh, you know, should these documents be, you know, should they be filed with the old law, the new law? Should we wait? So I'm sure
people are delaying filing their charges. People are delaying filing their charges so that they will pay 0.35%.
Exactly.
Against
Exactly.
2%.
you know this, RG. So still with you, RG.
Thank you.
One of the things that's been making the rounds recently is this whole thing about NGOs. The NGOs seem unhappy. Some of them, majority of them, right? And it has something to do with Section 8391. And if you look at that Section 1, it seems as if it's giving you wide powers to remove trustees, sack them, change them, and all that. And it's good for you to throw more light on this, RG. And particularly, it would be good to address two things: what you feel that your powers are as your interpretation of that section, and then to the extent that there is an amount of subjectivity, how the CAC intends to create regulations that, make it more objective than subjective.
Thank you so much, Chair, for that question. The controversy was actually unnecessary because these provisions are consistent with best practice. It's not peculiar to Nigeria. We have similar provisions under the Charities Act of the UK. In fact, our own provisions are nowhere close to what we have under the Charities Act. The Charities Act provisions are more stringent. Section 839 has two legs to it. The first part deals with the powers of the Commission to suspend trustees. And the grounds upon which that suspension can be made are clearly stated.
And if I may, when I read that section, it seems as if it has different legs to it.
Yes, let me finish.
839 talks about powers of the Commission, then court orders, then Commission going to court, and then members of the association going to court.
Let me explain, yes, Chair. I think it has more to do with the way the section was drafted. We had similar provision in the repealed Act, Section 315, which had almost the same kind of arrangement that has caused that kind of confusion. But what the provision is saying is CAC may suspend a trustee where there has been any misconduct or mismanagement in the administration of the association, or where it is necessary or desirable to do so for the purpose of protecting the property of the association, or securing a proper application of the property, or in the public interest, or where the affairs of the association are being done fraudulently. This power is not absolute because the subsection 7 provides that there must be an inquiry before that power can be exercised. And the inquiry will mean giving the opportunity to the trustees to respond to these allegations. And even after they have responded, this is a matter that may even have to be referred to the Administrative Proceedings Committee of the CAC. As you know, we have a new provision on Administrative Proceedings Committee, which allows CAC to look into some of these issues, and they can invite any person that is alleged to have done one thing or the other, and he's entitled to even have a legal practitioner to present him. He can either represent himself personally or have a legal practitioner. So even where the Administration Proceedings Committee has come up with a decision, that decision has to be approved by the board of the commission. And our board comprises of the representatives of the Bar Association, the Manufacturers Association, the Institute of Chartered Secretaries, Ministry of Finance, Ministry of Trade, and we even have provisions to have observers in that committee. And even after the board has approved, you still have to get the approval of the minister.
That's section 11.
Yes, so under subsection 11. So this power is not absolute. And as I have said, this is consistent with best practice, because why do we register associations under Part C? The major distinction between associations under Part C and companies registered under Part A is that these trustees cannot divide the income of this association among themselves. Whatever the association makes, whatever money that is realized has to be utilized to pursue the objectives for which this association is being established. It cannot be distributed to the members. So where you have this kind of infractions, you may not have to wait for 1 year, 2 years for the court to give an order to suspend a trustee. So the second leg relates to the power of court. And that one is wide. So our own interpretation is outside the circumstances outlined under section 83839 subsection 1, in any other circumstance, the commission may approach the court and request that a trustee be suspended. And the commission has to provide reasonable grounds for that to be done. Or 20% of the members can approach the court and seek for that intervention by the court. So as I have said, the controversy is actually unnecessary, and the powers is not the registrar general that will exercise this power. There are
the commission.
Is the commission. So even, and as I have said, even after the commission has approved, the Honorable Minister of Trade has to approve the actions of the board. And it's good to emphasize that this is not peculiar to us in Nigeria. We have similar provisions under the Charities Act. And fundamentally, we need to understand the fact that unlike companies, where the law says if you are carrying on a business under any name other than your forename and surname, you must register. For associations, you don't have to register with CAC. You can run your association without registration. The language of the law is may. But if you agree to register and you submit yourself to regulatory oversight, then you must behave in accordance with the law. Your actions must be consistent with the law and your constitution. So this is my answer.
Fair point, RG. Well said. Before I leave you, I'll just point out, I think if you look at that section 8391, right, there's a portion of it that says where the commission reasonably believes, right? And that's where, a bit of subjectivity comes in, right? And I think, this just by way of suggestion, right? Even though you are going to take such action by going through the board, I assume you will go through the board. The administrative proceedings committee. You will table it with the board of the commission first.
No, the first step is to take it to administrative proceedings committee.
Okay.
An inquiry will be made. Mm-hmm. Trustees will be invited to make their own representation.
Yes.
And they will be heard. They can have legal representation, and all the evidence will be reviewed. So if the committee, if the APC is satisfied that there are grounds to suspend, then it will approve, and this has to go to the board. All these facts will be made known. The records will be there. In fact, the law says we should even keep.
Where I'm going to, AG, right? Yeah. This is something that would need guidelines.
Yes, we are already working on it.
So that people are clear as to how the discretion and how that reasonable belief will be arrived at, and the processes and all that.
Very well, Chair. In fact, I have already discussed this with Dr. Dole and even some members of the SBR. We're going to have a committee that will work on most of these regulations and guidelines. And this time around, we're not going to do it in-house. We'll involve stakeholders so that we'll come out with standard guides and have stakeholder buy-in. CAC will not do it alone. Thank you so much.
Excellent. Thank you, RG. Thank you very much. Thank you. So let me move on. Just stand by. We may come back to you. Thank you very much. We will go to Dr. Jumoke Oduwole. And my first question for you is, you are very interested in the ease of doing business. So it will just be good for you to walk us through, the boxes that you think this act has ticked from an ease of doing business standpoint.
Okay. Where do I start? I think that, like you said, so first of all, the objective is to reduce cost and to make it quicker to do business, and then to layer greater transparency on our business climate. So if you talk about reducing cost and also making things quicker, that's why I spoke to all the virtual, all the electronic innovations in the Act. You already alluded to the new types of structures. You have the single member, single shareholder, the limited partnership, limited, so those are also, and then of course, RG talked about authorized and minimum share capital. I think that was Mrs. Best share. So you don't have to tie down capital. Those are some of the innovations. The statement of compliance allows promoters to just get on with what they need to do. Legal community, don't get upset. We're expanding the pie. We have a lot more registrations that we're expecting. The legal work will become more sophisticated, which means more fees. So let's not even be upset at all about things like declaration of compliance, which are really at the bottom of the food chain. There's a lot more to look forward to. So those are some of the things. If you talk of innovation, if you talk about cost reduction, of course, we've talked about, Ozofo talked about the reduction in the charges to 0.35%. And also we expect about a 65% reduction in the entire regime of registration of charges. And then you have transparency, good governance. You saw the Institute of Directors launching their ethics code about 2 weeks ago. Globally topical issue. So for us with public companies, you can't be a member of more than 5 public companies at a time. You can't be a director, sorry. And things like that. What this does is it makes sure that it's more transparent to do business in Nigeria. It's faster, it's cheaper. There's several of them. I can think of at least 15 off the top of my head. But as we all know, it's a really huge piece of legislation. And there's several nuggets in there to reduce costs, particularly for small and medium-sized enterprises. I shouldn't forget, again, no need to have a company secretary, it's optional, and an auditor also optional. Because at the end of the day, we want entrepreneurs to be nimble, to be agile, to be able to move very quickly. And I should say that this work didn't begin with Cama 2020. For the last 3-4 years, we've been working on digitizing processes, reducing forms, making sure procedures are online, timelines, 4 hours, 24 hours, so things like that. And I'm glad to see that the whole community is responding very well to this ease of doing business provisions.
Thank you very much, Dr. Duwale. A follow-up question to that, many times we pass laws and we expect them to achieve certain objectives, but we don't set key performance indicators and things that we can track over time, whether they're achieving those objectives, whether indeed, this has driven investment, whether it has grown the pie, like you said, are there things that you plan to put in place that will, help to track from time to time, whether the amended act is achieving its objectives?
Oh yeah, I mean, we don't have one specific to the act, and we may just take that on as a project as time goes on. We want to see where, from ground zero now, say in a year or 6 months where we are. But in general, the ease of doing business intervention, as you know, it's a national project. We work with all the state governments, we work with the National Assembly, we work with the judiciary, and of course, several MDAs at the federal level. So it's a very collaborative, intervention, very close partnership with organized private sector and with private sector as a whole. What this means is that feedback and verification, if we don't get validation for the projects that we set in place, for the reforms that we announced, then we know we're not there. But you can't even do these reforms in the first place without engaging with stakeholders and knowing exactly where the shoe is pinching. So we do look at empirical studies, global ones, external ones, like the WEF competitiveness report and the World Bank's flagship doing business report. Those are some of the rankings that we look at in terms of perception. But we're much more interested in the impact that private sectors say. They're all based on private sector feedback, but we're much more interested in the feedback that we get directly. And how do we do this? We engage constantly with private sector, stakeholder engagements, events like this that we're attending right now. We just had to stop our nationwide tour called Lituation, going to all the regions across the country. We've been to about 4 regions, and then Lagos and the FCT, but we had to stop going to Jigawa Northwest because of Lassa fever in February, and then COVID kicked in. But what we then did was to have a regional workshop with all the reform champions at the state level to see how we will take this further in our new normal. Now, another thing, let me just chip in quick.
Please
two things.
go ahead. Go ahead.
Yes. So another thing that we've been
we're here
working
to hear you and hear everybody.
Okay, so we stopped, we suspended, we had a cost of compliance survey that we were just we were just poised to release it on private sector. So this is a group of legal practitioners, so professionals, but we're poised to speak to actual entrepreneurs and get the feedback of the regulatory environment, cost of compliance in a holistic fashion. Because you have, for instance, NAFDAC regulated by Ministry of Health, you have SUN regulated by Ministry of Trade, you have FIRS under Ministry of Finance, and on like that, trying to get the whole picture. So that's a survey that will still come on board. We also have the subnational doing business survey. It's not called a doing business, but that's exactly what it does. It looks at areas beyond the World Bank's doing business, which is mainly a regulatory pocket. It also looks at things like security and infrastructure, access to information, workforce readiness across the country. So that report, we hope to have it done by Q4. We're still looking at the timing and the funding, but these are the empirical surveys that we use. In addition to things like our Executive Order 1, we've published 2 annual reports on Executive Order 1 on transparency and efficiency of public service delivery. And of course, our report gov.ng, which is where private sector validate and put in complaints and feedback about the reform interventions that we've done across the board, all levels and arms of government. Now, I would say, as Sheni alluded to at the beginning in his opening remarks, is that the SPL and PEBEC have been working very closely with NESG, with players in the federal government, MDAs, anchored by Ministry of Justice, to draft an omnibus bill. I mean, we've been doing it very quietly for about 2 years now, as you're aware, but I'm telling the whole constituency, we had about 40 law firms working pro bono on this with the committee chaired by Fola. But now that we have Cama out of the way, we have the finance bill out of the way, we were talking, Mrs. Bashir, as you know, anchors this from the PEBEC perspective, to throw it open now, and I'm glad to see that there are 1,000 people on the call. Since we've done away with some of the issues that private sector had in the finance bill and now in the Cama, we'd like to hear from you very quickly in the next 10 days to 2 weeks, provisions that would like to put into the new business facilitation omnibus bill. So I just chipped that in. It's a free advert, but I know that Tony Bashir will speak a bit more about that because it's her baby, and we'll take it from there. So thank you.
Thank you, Dr. Duwale. Just before I leave you, I do think that this particular law is the hub for business in Nigeria, right? Because, I mean, you can't do business without incorporating a company, right? So it would be good to have what I call trackers, 6, 7, 10 things, right? That if in a year's time we come back and we're having this conversation, you should be able to say to us, post this bill, the company incorporation statistics has gone up, right? We've had more companies incorporated in 1 year than in 5 years previously, you know, things like that. It just helps all of us to, yes.
The IG is right there. That's going to be, those are his statistics, and he will make them publicly available. The Corporate Affairs Commission already on a monthly basis gives the PEBEC information, and the Bureau of Statistics, the National Bureau of Statistics, also tracks the impact of SMEs into the GDP. So you have SMEs already at 48%, MSMEs at 48% of Nigeria's GDP, and already accounting for about 84% of labor. So those indicators are tracked. We'll be delighted to extract exactly whatever jump we see with the Cama. You can be sure that we'll be delighted to know the trumpet and tell the whole economy that collaboration works. The last thing I would chip in case I don't get back, is just to commend the National Assembly, the 8th National Assembly and the 9th National Assembly for really demonstrating a continuity in government. The reason why the Cama has been ongoing since 2004, that's the amendment, is because government has not always worked as a continuum. But the 8th and 9th National Assembly have really shown us how it's done. colleagues have just continued in a continuum and passed this bill for us. They could have sent us back to the drawing board, but they didn't do that. And here we are today in record time in a new dispensation. So I thought I should commend the National Assembly publicly.
Fair point. Thank you.
Yeah,
we should commend you too. We should commend you too for all your hard work. Yes, RG, please.
Yes, what I want to do now is we'll be putting the registration statistics on our website from tomorrow. So this will enable anybody to track by the time the new Cama comes into effect. At least we have the figures that we have now in comparison to what we have when the new law comes into effect. So we'll start
nobody will registering businesses right now. We are waiting for the new law.
No, we'll start now. So every day we'll put the number of companies registered a day before, number of business name, and number of incorporated trustees. From tomorrow, this will be on our tweet and our website. Thank you so much.
Excellent, RG. Thank you. Let's come to Nana. Dr. Duale talked a lot about SMEs, and you are from the NESG. I know that that's part of your space. I would like you to talk about what you think the major economic drivers are. We've passed a new law. How does it affect the economy? How do you think it will drive the economy? And then particularly SMEs. What do you think this law brings to SMEs?
Okay, thank you very much, Ayuli. Like she said, one of the direct impacts of a legislation like this is on the business environment, improving the business environment. And for us in the NESG, we did an economic impact assessment of this kind of legislation. And one of the things we found out was that there is a global research which suggests that when a country moves from the last quartile of the doing business ranking to the first quartile, it produces a 2.3% increase in GDP. Now, what that implies is that a 10-point improvement in your distance to frontier scores produce at least a 0.23% growth in GDP. Now, based on this benchmark, these improvements in the business environment are projected to impact the GDP by an average of 5.15% growth per annum. It projects that it will boost per capita income by an average of 2.49%, and that it contributes towards a 2.5% reduction in poverty annually. Now, how will that happen? For instance, we talked about the single shareholder limited liability companies. What that then happens is that it opens up the door for more enterprises that were in the informal economy to get into the formal economy and create jobs. So in the impact assessment that we did, we had projected that in the first year, we expect that by just migrating these enterprises into the formal economy, we project creation of about 2.3 million new jobs in the first year, additional 2.4 in the second year, another in the 2.9 in the third year. And so these are critical economic indices that will be transformed directly simply because we have a legislation like this in place. And speaking to the point you made about SMEs, she had said that MSMEs contribute about 48% of the GDP, but the informal economy as a whole contributes 65% to our GDP. Now, formalizing the informal economy is critical to economic growth. Why do you have many of them outside the formal sector? The burden of administrative procedures, the high documentation required, and then what does that lead to? Lack of access to credit. Because when a company is a business name or an enterprise, banks will not grant credit to such an enterprise. Mm-hmm. And so what is the direct implication of that? Suboptimal contribution to the economy, suboptimal contribution to growth of the business. And so for us, we are excited that we have this kind of reform legislation in place, because it's going to hit directly at the growth of MSMEs and ultimately the growth of the Nigerian economy.
Thank you, Nana. sometimes there's a conflict between growing GDP and growing businesses, right? I mean, you are able to track GDP when someone transits from the informal into the formal economy. But people in the informal economy are afraid of getting into the formal economy because it comes with higher taxes, higher regulation and things like that. So even though you've passed this law, I mean, my thinking, and this is open for discussion, is that there will still be a lot of work to do to try and convince people in the formal economy that this is a good way to go, particularly with VAT going up, all kinds of taxes here and there, government trying to claw back. So, I mean, what do you think would be a good way to address this conflict?
Yeah, my response to that would be, this is just one legislation in the entire raft of business environment legislations that we are working on. Pebek, Dr. Jumoke had mentioned the other ones that are in place. We have what we call the National Assembly Business Environment Roundtable, and we are working on about 50 to 60 legislations that deal with the entire business environment space. We have regulations, we have taxation, we a lot of them. And so we hope that as we tick these boxes moving along, we had actually done some a bit. Jumoke will also talk about the credit reporting and the secure transaction in movable assets. Those had been done last year. We still have a lot more to do going forward. So as we pass these laws, the importance of, because it's easy to issue an executive order or to do a policy, but the work that is going on is to encode them in laws, just so that they are not easily uprooted when you have moved from one administration to the other.
Absolutely.
And yet some people can say, yes, even if you have a law, will they be obeyed? But our counterpoint is always, let's have the laws. Those who don't obey the laws will ultimately become lawbreakers. So if you don't get them today, you will get them tomorrow. So, but let's encode them in laws. And the journey of growth and transition is not a one-day journey, it's not a one-month journey, it's not a one-year journey. But we start by putting the laws in place, and ultimately, with institutions like CAC and all the rest of them, we hope that we'll just start this journey and keep moving out as we go on.
Thank you very much, Nana. Just to chip in, I mean, I think that one major thing that the NESG should look to do in this period is to constantly have more engagements with people in the informal sector and try and break them into moving to the formal sector and make them see that these laws are not traps. People in the informal sector just believe that laws are just traps. You're going to
just to chip in that, about just less than a year ago, we have established a community of practice to achieve that. And we have done that within the last 1 year.
Excellent. Thank you very much, Nana. Thank you very much. So just hold on. Let me move on to Tony Bashir. Tony, are you there?
Yes, I am.
Yeah, okay. So, I mean, this thing has not been all rosy. I mean, there's been so many criticisms. I mean, people have thrown stones at this law. I mean, it happens. There's no perfect law. And, I would like you to pick one or two of those things. And particularly, there's this issue around BRIPAN, which people say, it's a private sector led organization, and then it was put into the CSC. Why should that be? If you address that and one or two other things, just to enlighten us.
I mean, just like you said, most of us have read, we've watched, different personalities physically dissect that provision of the law. I mean, this is section 705(1) of Cama 2020, which has introduced some kind of licensing regime for practice of insolvency in Nigeria. I mean, the section goes on to define who is an insolvency practitioner and also lists the qualifications of such persons. There are about, I think, 4 ingredients in terms of the qualification, but of course the naughty and controversial bit has been the recognition of BRIPAN, that's the Business Rescue and Insolvency Practitioners Association of Nigeria. You had mentioned, and that's correct, that the questions have ranged from whether it was lawful to have recognized a private non-governmental organization in a legislation, and also whether this provision essentially serves to remove or force interested parties to join BRIPAN, so thereby restricting the practice of insolvency to BRIPAN members. So I mean, my first thoughts usually when I see changes in legislation is to try to figure out the intention of the draftsman, and also try to find out, whether is this practice usual, is it in line with global best practices? Are there available, similar practices in progressive jurisdictions around the world? Now, a little bit about BRIPAN. Of course, that led me to, look at BRIPAN a little bit more closely. So BRIPAN is a non-profit association. I understand it was set up in 1994, and essentially is to promote insolvency practice through training, engagements. Initially, I think Insolvency Practitioners Association of Nigeria. But when the focus of the world, when the focus then moved to business rescue, that is essentially saving financially distressed companies, it migrated to BRIPAN. And so we now have in Cama 2020, the inclusion of, a new legal framework, compulsory company voluntary arrangements. We have the administration. Some would say these are sophisticated arrangements. Some hold that view that it's highly technical. So for me, and you did ask for my view, it's not impossible that the idea was to take advantage of a group of professionals who are mostly lawyers and accountants anyway, to sort of push the implementation of these processes faster, essentially to enjoy, so that companies can enjoy what the provisions are seeking to, to do. I also discovered it was not uncommon for some jurisdictions to recognize professional bodies in their respective legislations, actually, yes. While it may be unusual for Nigeria, but to the extent that, and I would be happy if anybody can correct me, it hasn't been determined as illegal. So for me, I struggle to, find fault in such inclusion. It's new. We're going to be the people who would start essentially using these laws to support companies already have a basic or even a deeper understanding of these new provisions. I think is a good way to start. But more importantly, the relevant subsection doesn't actually list BRIPAN as the only professional body CAC would consider.
It says or any other organization that the CAC may consider fit or something
Exactly.
to that effect. Yeah.
And it's so curious that most of the people who have pushed this narrative out there just always, forget to mention that bit. So it's like BRIPAN and nothing else, I mean, the section specifically says it empowers CAC to consider membership of any other professional body recognized by the commission. So for me, instead of focusing attention about how appropriate or inappropriate the inclusion of BRIPAN is, which, it's one body, I think it would be more productive if we focus on identifying which other professional bodies CAC should consider and start making a case for it, and start speaking with Alhaji Abubakar there, who always is open.
RG, I think you should be the one who should, put out something to say, interested people who think they fit that bill should send in their profiles.
Interested organizations or individuals?
Organizations, of course.
Organizations, yes.
Fine,
definitely.
yes. It's part of what we intend. We'll actually do that. But, we all know the category of professionals that are usually involved in insolvency practice. They are mainly lawyers and accountants. Mm-hmm. And what the law has done is you don't have to be a member of BREFA to actually engage in this activity. So that people will not use, if you say it's exclusive to BREFA, it means everybody has to become a member. So any lawyer outside, whether or not he's a member of BREFA or any a chartered accountant who is qualified, or as you have said, any other professional may be accredited to engage in that line.
So as a member of the Nigerian Bar Association, I can be
accredited. You are eminently qualified. You can. most of the liquidators we register either lawyers or accountants.
I don't have to belong to BRIPAN. I can just tell you that I'm a member of the NBA.
You can.
And accountants can say they are members of ICANN, and will that qualify them?
Or any other body of accountants. But if I may chip into the issues, what the argument is, the law is recognizing a private association. They are not even talking about the competence of the persons that are actually members of BREFA. They are talking about the law, but they forgot to advert their minds to even the earlier sections of the law that talks about membership of the board of the commission. You have representatives of Manufacturers Association of Nigeria, which is a registered association by CAC. You have NASIMA, you have MBA. So I don't know, the argument does not hold any water because there's actually no basis for that argument. If any group, most of these groups start as associations before they get their charter. The Institute of Arbitrators started as a private group. ICSAN started as an association registered by CAC before they got their charter. So are we now going to say that because there is no charter for BREFA, we shouldn't recognize it? So I think we should move forward. These are just
fair point, RD. Fair point, RD.
So I guess we're waiting for CAC. We're waiting for CAC to come up with their pronouncements on that, just so that there's more
chip in as well.
There's more certainty around it.
I think just to chip in also that speaking to the associations, because Mr. Moderator, you raised a point, Mr. Jamide, whether or not the CAC should invite associations or whether associations, I don't even think the CAC needs to invite. If an association, for instance, the Nigerian Bar Association, immediately goes into its constitutions, or it's just, whatever the association wants to do, to say our members are also competent to practice business rescue, that should suffice, because it's already known to CAC, and you're now giving your members legitimacy to enter into the business rescue space. I'm thinking about the companies and the competences that the companies require for their business rescue, which is quite technical. And at that point, businesses are vulnerable. The whole point of business rescue is to make sure that creditors do not cannibalize the business. So rather than professionals having a field day, let's even just step back and think about the vulnerable businesses that are in a place of distress and the kinds of competencies that they require at that time. And the thinking behind the law is to really make sure that the people that are giving succor to those businesses through that turbulent period of headwinds are competent to do so and don't make matters worse. So I think that we should actually think about the businesses that we all will be giving our professional services to.
Dr. Dole, thank you very much for this. The NBA SBL will surely ride on this. We're going to make our own proclamations.
If I may also interject.
To protect our members and push them into this space.
I'm surprised you haven't already done so.
Well, the law has not been gazetted.
Well, informally.
Okay, we will do so. So let's move on to independent directors.
I think I heard Mr. Chair trying to get your attention.
Yes. I was just, I guess it might amount to beating a dead horse because I think it's been fairly well or very well articulated. But I think instead of the criticism, those provisions should actually be commended, because even part of the context of the provision dealing with business rescue has to do with the fact that another very, very, very significant bill that still hasn't seen the light of day is the insolvency bill that's still pending before the National Assembly. The provisions, this business rescue provision, were an attempt to at least get something in Cama, and as Dr. Oduwole said, such that most of the practitioners in the area of bankruptcy or reorganization, business reorganization, essentially engage in receivership and liquidation. There's no such thing as business rescue to speak of. So to the extent this Cama has those provisions, people should be lauding the statute and people behind that statute as opposed to criticizing, because what we've gotten through the business rescue provisions is at least now, as Dr. Oduwole pointed out, companies are able to, on their own volition, seek protection, go through a reorganization process, and come back, hopefully, being healthier businesses. And a lot of these issues, the IG has already talked about, in terms of who's eligible, who's qualified, can be done through implementing regulations by the CAC. So it's a lot of people trying to be mischievous when some of these issues are not considered in a very wholesome, from a very wholesome perspective.
Thank you, thank you, Chair. So Tony, let's talk about independent directors. And it's always interesting when I think about the concept of independent directors, because independent directors are nominated by certain people, and I always think to myself, to the extent that someone nominated them, how independent are they, right? And we need to take into cognizance that the law is now saying that public companies must have 3 independent directors, right? And if you look at public companies in Nigeria, they're between 160 to 180 public companies. So if you do the numbers, for public companies who have not, who are not complying with this, it's a lot of new directors that are going to be thrown into the into directorship. I mean, let's just take a straight line. You are probably looking at 400 and something new directors, and then you can begin to shave off from there for companies who have 1 independent because they are SEC regulated or PENCOM regulated. But I think it's important for us to understand who an independent director is and what you think this provision is trying to achieve.
Okay, I mean, yeah, you have set the tone. Truly, how independent are they? I guess, I mean, the whole rationale for introducing independent directors was essentially to also improve decision-making on the board anyway, to make it more balanced. But broadly speaking, they are directors without substantial, probably commercial or other interests in the company. So Section 275, like you mentioned, has now sort of like prescribed a minimum, actually, a minimum, because it speaks to at least 3 independent directors, so there could be more. So that's the first thing. And then it goes on to define what Cama 2020 recognizes as, who is an independent director. So then prescribes, the criteria, talks around, not having taken employment with a public company in the preceding 2 years, talks about, share thresholds of 30% in the company, 30% and above in the company itself, and even in another company which has received a sum more than 20 million naira, because there's also, the monetary threshold that you had, that such director should not have received or given the sum of 20 million naira to the company in question in the preceding and understanding or for purposes of compliance with to our jurisdiction. We know that, and you did mention that the regulated public companies, they are mandated to comply with similar provisions further to the relevant codes of corporate governance, which I think mostly prescribe the minimum of 1 independent director.
1, I think it's 1.
Yes, it is 1. And then, of course, we have, the Nigerian Code of Corporate Governance 2018, which doesn't prescribe a minimum number, but then it states that it's desirable for most of, the non-execs on the board to be independent. So when we look at the provisions of Cama, we have to also see the other provisions. I mean, the Code of Corporate Governance is a mandatory provision, a code rather, for public companies. So it complements that bit, I guess, around where, you know, they are these large boards, and then, you know, you have to have a minimum number. It kind of like balances it out. I mean, it's stringent, but I guess it's more important that compositions of boards now, the immediate thing, I guess, for most lawyers and everyone on the call who have clients that are public companies is to evaluate the board to ensure that they're in compliance with these provisions ahead of when we see the gazetted version of the Act. Of course, the advantages of the provisions are not too far from what we all know, that for having more independence on the board, I mean, less to nil vested interest. The provisions of Cama has clarified what will be perceived as vested interest for people who want to understand what that means. So once they cross the relevant thresholds, the 30% and the provisions as regards the amount as well, 20 million. And I think there's also a provision that you shouldn't have been appointed an auditor for the 2-year preceding, the appointment. So such people would not be considered as an independent director for purposes of appointments on the board. So ultimately, the provisions are to safeguard, stakeholders and shareholder interests in such companies by ensuring, board decisions are taken in the interest of such shareholders and the relevant stakeholders.
Thank you so much, Tony. Thank you. Very useful. Let's move on to Ozofu.
I'm sorry, Mr. Moderator, before we move on to Ozofu, yes. I wanted to ask Tony something. There's been some concern about the 30% threshold for independent directors. It just seems a bit high for an independent person to be able to hold up to 30%. I just wondered I wonder if you could address that for those that have that in mind that are participating in this webinar.
I mean, it is high, it is more stringent. And I think the codes refer to paid up, I think, other than shares. I don't know if the fact that this refers to 30% of shares, whether or not it's, paid up or not, may influence how, one can reduce some liabilities in that regard. But I guess, I mean, it's a compliance issue right now. We'll see how the law essentially works in life. In the coming months, we'll see how it then works out with most boards. And I'm sure CAC, and I think somebody had mentioned the fact that it's not a perfect law and that we will continue to see sort of like get feedback in relation to the application of the laws. And a law in itself is not a document. Even though Cama is taking us 30 years to get here, I don't expect that it will take us that long to move forward. I think once you get started, the process gets faster. So we'll take, I mean, just like some other provisions that some people have concerns with, the concerns will be taken on board, will be reviewed, we'll see how it operates in live form, and we'll look to the future to see whatever amendments are required for the law.
Thank you. Ozofu.
Yes.
Still on this point, right? So the law says during the 2 years preceding the time in question, that's 2 years preceding the time when this independent director is supposed to be appointed, right? He or she should not have owned more than 30% share or ownership interests in this company, right? So is that to say that by the time this person is being appointed, this person should not hold any shares, right? Because I mean, what's the essence of the 2 years preceding, right?
Yeah, I mean, I think we're all trying to understand that. The reason why I actually flagged that issue was because, like the Code of Corporate Governance says, for an independent director should hold more than 0.01%, I think, of the shares. So, and this act, the Cama says 30%.
Of the paid up capital, I think, of the company.
Okay, but Cama says in the preceding 2 years, you shouldn't have owned more than
Yes, during the 2 years preceding the time in question, this person did not own.
Yes, more than 30%, which
Yes.
means if you own 20, let's say you own 29.
That is still high.
It's
That's
high.
your point.
No, yes, my point is that it is high, but you will qualify as an independent. But I think the question is, can we say that a person that owns 25% of a PLC, which is by any means a huge feat to actually be able to own 29% of a public company, is a significant interest. Can that person in any circumstance be considered independent? So I think
this is a far stretch, but I'm thinking that perhaps what the law meant was, or means, is that at the time you are being appointed, you shouldn't be a shareholder. And not only shouldn't you be a shareholder, you shouldn't have held in the 2 years preceding shares of that threshold. I mean, could that be an interpretation? You don't think so?
I don't think so at all.
Okay.
I think you can be a shareholder, and provided your shareholding is less than 30%, you are fine.
Okay.
As at the day they're appointing you, you are appointed, and the 2 years preceding, you never crossed 30%, you will be eligible to be appointed as an independent. And well, I think, as Tony said, and that point has been stressed in all discussions about the Cama, we should learn from the past. We shouldn't let 30 years go by before we fix these sort of things, because we now have a conflict between this and the Code of Corporate Governance. So we need to be able to provide clarity and guidance so that companies are clear and they don't inadvertently breach, comply with one and then end up breaching the other.
Ozofu, are you suggesting that perhaps guidelines from the CAC or regulations can help to smooth out this conflict? Do we necessarily have to go back to amend this law, or we can use guidelines from CAC to,
I think that question can only be answered on a case-by-case basis. So it depends on the issue, and there are several issues. So even without issues or criticisms of the bill has put a lot on the CAC, that the CAC is compelled to issue guidelines, even if only to specify penalties. Then there are some provisions where, and I'll give you one that came up yesterday. There's some provisions where I think maybe from a drafting perspective, the clarity that's required is not doesn't come through sufficiently in the Act, and the CAC can provide clarity. I think that there are a few other issues that might be beyond the capacity of a regulation to fix, and that would have to be something that will wait till there's an opportunity to look at this bill at the National Assembly again. So let me give you an example of an issue that regulation can fix. That is Section 240 of the Act, which talks about general meetings. So I think subsection 1 says, other than single member companies and small companies, every company should hold an annual general meeting in Nigeria. Then the next subsection 2 says private companies can have virtual meetings. So 1 suggests that if the only companies that don't have to hold their meeting in Nigeria are single member companies and small. So there are some private companies that are not single, that will not end up being single member companies or small companies. Yet those private companies are allowed to have virtual meetings. So the question came up on the webinar I was speaking on yesterday. So should those companies, so if they hold their virtual meeting, how do they also comply with holding it in Nigeria? Then and people were suggesting maybe the company secretary should be in Nigeria. But I think that was not the intention. And I think it's a drafting thing. And I think that can be clarified with regulation, so that if the law allows you as a private company to hold a virtual meeting, you should not be compelled to establish that when you dialed into the virtual meeting, you were in Nigeria. I think the whole point was so that you can do it wherever you are, and your minutes will show you held it virtually on Zoom, on this day, rather than saying, well, the company secretary was in Lagos and then the director was in London. So I think that those sorts of issues can be clarified by regulation.
I agree with Ozofu, and I think it's important to also point out that you know, the regulations, what it can do is really to provide that clarity. It can't really amend the substantial provisions of the law. And I guess, as the RG mentioned, that he's going to make that the process for generating those regulations very open. So I think it's very critical for us as lawyers who have identified those areas, just like Ozofu mentioned, should escalate that to whatever committee. And I hope that the CAC will be very transparent to enable people figure out where these comments are supposed to go, because it would only make that process, you know, much more robust and useful at the end of the day. Yeah.
Thank you, Tony. Ozofu, do you have one more thing to say regarding criticisms of the act? Dr. Duale, were you going to say something?
I was going to say something.
Please go ahead.
Move on from that point, because I see that, I mean, I have to speak up for my RG here. A lot is being put on CAC, and some of these issues, like Tony said, we're only going to know when the act really just comes into operation. Ozofu, you said yourself, it may be case-by-case basis. We have the courts, we have the learned silk right here. Sheni, here you are. We are going to argue some of these things. So
no, we want to try to resolve it without going to court, man.
I know that. I'm just giving the issues, but where
whose side are you on? Come on now.
But where I actually want to rest is that the National Assembly is not closed. It's not closed off. We have a very robust collaborative spirit going on here in terms of reforming our legislative climate. As Nana had also talked about, we have several things we've been working on in the last couple of years, and some are coming to fruition as we speak. So let us also not shy away from going for amendments as required, not with frivolities, like very serious amendments, going back to the National Assembly together to talk these things through with the appropriate committee, and very quickly we can have amendments as required. It's a living legislation now. We're not going to wait another 15 years or so before we have you know, the bills we want. You know, basically annually or as we go on, we can just have amendments. So
fair point, Dr. Duale. I mean, it's easier to make amendments.
Can I
yes,
chip
exactly.
Okay. Can I chip in something on the issue of meetings? As also rightly observed, I think there is a drafting error. The intention actually is small companies are exempted from holding annual general meetings at all. So small companies are not even supposed to be within the purview of that provision. It's only private companies other than small companies that are required to hold annual general meetings. A small company doesn't have to hold meetings. They are exempted from audit. They're exempted to filing financial statements with the CAC. But other private companies, there may be big companies that are private, like EcoBank and others. So those big private companies have to hold their meeting. And what the law is saying is, can they hold it in Nigeria or outside Nigeria? So you can hold it outside Nigeria. And which means, in addition to public companies, those other private companies cannot. But for a small company, there is no requirement for annual general meeting, actually. So as Dr. said, well, we need to engage the parliament, but I don't know whether it's the right time now. Maybe we allow the dust to settle before going back.
We will use regulations for now, RG.
Yes.
Yeah, I just wanted to also add that.
Cama wants to go to court on this issue, so we won't allow him. We'll use regulations.
Can I just make a point?
Dr. Duale, thank you very much for the plug.
Yeah, I just wanted to add that, you know, from our experience working on a lot of this legislation, there another forum I made a point. I said, I do not know of any country where they enact perfect laws. And so, like Dr. Jumoke said, let's get the law in operation. We will amend what requires to be amended. We will then use regulations to correct what can be corrected. But let's not just get these laws and begin to tear them down from the very. Working on these laws has been very, 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 very tedious. So you find, there was one we were looking at yesterday. We just missed out one sentence before we sent it in. So it's hard work. So, but what matters more is what's the general impact that the law is to deliver. And can we begin to make it work and begin to make it work? There's no country in the world where they enact perfect laws.
Yes,
No.
totally agreed. Totally agreed. Ayoyinka, do we have questions at this time?
Yes, sir.
Sorry, moderator, I'd like to fight for my opportunity to respond to the question you had.
Yes, please. Please, you don't need to fight. Just go ahead.
I'm very grateful that the most contentious criticism has been handled by the RG. So thank you, Mr. RG, for saving me from having to defend that one. The Bripan criticism has been dealt with by Tony, I think, excellently. But the reason why I wanted to address this question was some of the debates that are going on suggest that people are not actually taking time to read the law. And if you're not reading it, you can't tell when people are misleading. I was going to respond on some of the various criticisms. So there was this one about all foreign companies must register except Chinese ones. I saw that online, and you know, I think beyond saying that's just a lie. I don't know what else to say about that. So it references section 80 of the Cama 2020, which is really what used to be section 56 of the Cama, the previous Cama 2004. And when you read the provisions, there's no reference there to Chinese companies. In fact, there are no changes. The provisions are the same as what we've always had, which is foreign companies must register in Nigeria in order to do business. And then the federal government has the power to grant exemptions. And the exemptions are the same as what they've been before. But if you read that article without going into the law to see it for yourself, you will actually believe that something has been inserted that said Chinese companies shouldn't register. So I think that it's important that we let people know that before, you know, while these debates are going on, we need to make sure we're looking at the law so we can separate fiction from fact. Another criticism that I wanted to also address was section 863, which has been criticized for criminalizing small
Zulfun, just before you go into that, I just wanted to make a point in relation to what you just meant about those provisions.
I think we lost one.
Provisions relating to foreign company exemptions. And I think the only reason why it was flagged in the first place was because where you are supposed to go and seek that exemption was changed. I mean, that was the only thing. Minister of Trade, Investment, Industry, Trade and Investment. Essentially, the whole point was a find who you were going to be making that application to. I mean, I've had situations where I've sat with senior members of the supposed team in the office of the secretary to the government, who are lawyers, by the way, who absolutely had no idea that those provisions existed. But because this relates to trade, you know, it's more suitable for that particular ministry. So I believe that that was the intention. So it was very amusing to see that it now became, you know, about the Chinese, you know, very confusing.
Yes. So there was another one on section 863, where the law, where it has been alleged that the Cama is now criminalizing small businesses that are operating without being incorporated, and so maybe 21 million Nigerians are at risk of committing a crime and, you know, being fined and all that. But if you look at section 863, and the RG had alluded to this. So it says persons or associations of persons shall not carry on business in Nigeria as companies or limited liability partnerships or limited partnerships or under a business name without being registered. And as the RG had said, what this section is saying is you can't carry on business as a company or as an LLP or as an LP without registering. But there are many people, the woman selling granuts at the side of the street is not carrying on business as a company. So it's what this section is saying is, and then the subsection 2 says, if you are required under this act to be registered. So for instance, the act says that if an association of more than 20 people are carrying on a business for profit, they have to register as a company. But if you are not an association of up to 20 people carrying on business as a profit, for profit, then you don't need to register. So I think that it's important to make this point so that it doesn't seem as if we're saying the person selling recharge card and the person, the vulcanizer at the corner, have to register a company. I think that one has really been misunderstood.
Can I just add a little to that? Moderator, can I just add a little to that? Because I actually wanted to speak around this when we spoke earlier. I think for me, it's also the lack of information. That provision isn't exactly new. I mean, it's just the only bit where it's now, brings the sanction, it criminalizes, the action of, undertaking business without registering. But because people have done it for so long and have remained non-compliant, it seems so new, like what's happening. I've been able to carry on business with my trade without actually registering it. But that's actually always been a requirement. The only thing is that I believe that CAC must have recognized that there was huge non-compliance. And then CAC is part of government now. So they are trying to, if they are trying to widen the tax nets, whether it's for state governments, in this case, which relates to business names, I think it's quite in order. So for me, it's all about how CAC is going to implement those, the provisions. You must remember that you're dealing with MSMEs and the fact that they do not know. So the process for transitioning, because you know that these people now have to move from informal into the formal sector, I think that is what is key. You must have a process of onboarding them. It's not just and hitting them with sanctions. I think South Africa has some process where you send in a notice of non-compliance when you find that people are not, and then you prescribe a time frame where they can actually register, because you need to tell them that the whole purpose is not to punish. The whole purpose is just to ensure you comply. So it's not a revenue generating move by the commission, but just to ensure that people, establish formal structures for taking businesses.
Understood, Dwayne. Thank you very much. We do have to go and get the participant engaged at this point in time. So far, it's been very, very engaging among the panelists. We've heard all the good sides about the law, but we've also seen that there's no perfect law. We've also seen that we need regulations to smooth out things. And I would like to throw it out there that the RG has said that these regulations will be transparent, they will be out there, people will have an opportunity to contribute. RG, I think the NBA, SBL will be happy to gather these regulations, and if the email addresses of participants here, we can circulate and get their comments and send back to you so that as many people as possible can contribute to your regulations to make it more robust.
Yes. What we intend to do, moderator, is we'll have a committee of major stakeholders, SBL, IOD, other major PEBEC. We have an in-house committee that is working on the first draft. As soon as they finish, a large committee of stakeholders will look at it. Then we expose it on our website, inviting for comments from the general public. So similar to what we did with our revised checklist, we intend to adopt the same approach. But the only difference this time around is key stakeholders will be involved in coming out with the final draft, similar to what happened to Cama with the NASBA roundtable.
Excellent.
In-house.
Excellent. Excellent. So on that note, Ayinka, where are the questions?
Okay. Yes, sir. So we have over 100 questions, and we'll try and get through.
We won't be able to take 100 questions, Ayinka, but let's start and see where we get to in the next 20 minutes or thereabouts. So over to you.
Right. So a lot of the questions are directed at the RG. We've had several questions regarding the implementation of the new act and why the CAC is waiting on the act to be gazetted prior to implementing the new provisions.
We've answered that, Ayinka. Anybody who was on this Zoom call knows that the answer to that. So I think we should move on to another question. The answer to that is very straightforward. We have to wait for the Gazette.
Cama 2020 seems to have encroached into financial reporting, auditing, and corporate governance regulations from the Financial Reporting Council that is legally authorized to do so. To what extent will the new act conflict with Section 59 and other relevant sections of the FRC Act vis-a-vis supremacy of the FRC on these areas?
RG, over to you.
Well,
and maybe Jumoke,
what we have done with Cama is Cama has minimum standards. Nothing stops sector regulators from issuing their own guidelines that may be more stringent than the Cama. Even on corporate governance, the issue of independent directors, the provisions of the FRC code on independent directors may be different from what you have, but at least you have the minimum standards that are now codified in Cama. CBN may have a more stringent regulations. Insurance Commission may have a more stringent regulations. The provisions of Cama are laws, not regulation. The Code of Corporate Governance issued by the FRC is a regulation. It's actually a code. So Cama will have more force of law than any regulation. But what we are saying is nothing stops any sectoral regulator from issuing guidelines or codes that are more stringent, peculiar to its own sector.
RG, what happens if Cama's regulations are more stringent than the
then you have to go with the Cama. You have to go with the Cama.
We have to go with the most stringent one.
Yes, the most stringent.
I think that's the point. That's the point that the person asking that question is making.
That is actually the spirit of even the FRC code, comply or explain. There are different standards, different practice directions. You take the most stringent. And what the FRC Act says, why there's a conflict between the FRC Act and any of the sectoral guidelines, you take the most stringent one. So if Cama is more stringent in the circumstance, then you take Cama. In any case, Cama is a law, so it's not a regulation.
Let me say private sector from our regulators. So what I would say is that we'll try to make sure that there are no silos. We try to make sure that the stakeholder engagement is fluid within government. I mean, speaking from the presidency, the PEBEC works with almost 55 ministries, departments, and agencies just to make sure that they're speaking with each other across the board. There's a lot of work to do. We've taken it in phases of what we work on. We also follow legislations closely before they get to the assent, before they get to passage, not to talk of assent. So we try to attend public hearings, and even before getting to public hearings, we try to pay attention to all sorts of, recently my attention was just drawn to the local content bill. So it's a discussion. When private sectors see, like that question that just came up, it's immediately to flag it, and we'll talk with the various stakeholders, whether it's a bill in progress at the National Assembly, whether it's a regulation coming up with a particular regulator. We at the PEBEC, and just me personally as special advisor on ease of doing business, I'm really here with my team to make sure that regulations, the regulatory and legislative environment enables the business climate of Nigeria.
Thank you. Yinka, what's the next question?
The new Cama empowers the CAC to act as court or tribunal of some sort, raising the question of transparency and just judgment of any case brought before them. What measures are in place to ensure that justice prevails in each judgment? I think this has to do with the administrative
committee.
Yes. I think that question has been answered. Anybody who was on this Zoom call will know that the RG took us through a process and how eventually decisions are made and how you are entitled to be heard, and you can be heard with your lawyer. I think that has been answered. Let's move on to the next question, please.
Okay. There are several questions about existing small businesses who have more than one shareholder and how they will go about reducing it to align with the new law. So,
RG, People are asking if I have 2 shareholders and now that I'm entitled to 1 shareholder, can I sack the other shareholder and just be by myself? How
Can
do
you
I
really
go about
sack,
it?
if he has paid for his shares, can you sack him?
Well,
If you are ready to take over the company, you pay him off, then you take over, we'll register your interest 100%. So that's not a problem. If you are ready to buy his shares, we'll register your interest.
I think the other option will be just go and start a new company by yourself.
No, he may even,
Yeah.
as I have explained severally, most companies that have 2 shareholders, you'll discover that the second shareholder was a child of necessity. He was just included to satisfy the legal requirements. In most cases, he doesn't even know how the business is being run. He doesn't know how the money is being made. He may not even have paid anything for his shares. So if the main shareholder feels he wants to remove him, provided they follow let down requirements, we'll accept that, and the company will become a single shareholder company.
Excellent. Inga, the next question.
Okay. How can we reconcile the request by relevant tax laws that company returns to FIRS be supported by audited financial statements when the new act makes it optional for a specific category of business?
Okay, who wants to take that? The RG, are you taking that?
Let me explain that, Chair,
Please,
Moderator.
please.
This is one area that we need to align the provisions of the Act with the Finance Act on the threshold of turnover for small companies. The Finance Act provides for 25 million threshold. And incidentally, the new Cama says 100 million turnover, 50 million net asset, or such other sum as may be fixed by the Commission. So what we intend to do is in our regulations, we will bring down this threshold to a lower level to make it in line with what we have in the Finance Act.
Excellent.
So that we have a uniform threshold. Any company that has 25 million turnover is exempted from paying tax. They still make file tax returns, but they're exempted from paying tax. So that will now make the laws to be the same, on the same page.
Yes, yeah, to deal with that conflict. Thank you, RG.
Okay.
Inga, the next question.
This question is for Dr. Oduwole. It says we've been filing incorporation documents with the CAC in the last few months, and it has been an arduous process. This makes
what do you mean information documents? Is that Freedom of Information Bill or what?
Incorporation.
Incorporation, okay, incorporation, okay.
This makes one to wonder whether the CAC has the capacity to implement the new Cama, which of course requires more usage of e-facilities. What does the government intend to do about this, as many SMEs are stuck with the CAC incorporation process?
I think that that's a bit of an unfair statement at CAC. CAC has been reforming its processes, electronic and digitization since 2016. Well, let me just say 2017, the reforms kicked off, and they've been going quite well. Of course, they're not exempt from challenges. In particular, this year, the main challenge had to do with the portal, and that happened just on the eve of the COVID lockdown. And it was issues with their vendors. I know this because I work very closely with the CAC, and it was issues with their vendors. The Registrar General and I, we were in touch throughout the lockdown period and with the vendors. I was also in touch with the vendors. Mrs. Bashir was meeting with everybody because we did get a lot of complaints through our report.gov.ng on the processes and the installation. What I would appeal to private sector is to please bear with us, bear with the CAC. The issue has now been resolved. It's back up. Of course, a bit of a backlog, a lot of people trying to get on at the same time. Capacity issues, electronic issues, they have definitely the competence and they have the budget. At least they're being supported. I know the ministry is also supporting, and they have the capacity to do this work. They've been doing it. It's not even new. When it comes to reservation of business names, when it comes to incorporation, they've even gone ahead waiting for the act. They've gone ahead to improvise, just that you had to bring the documents at the last stage. But now with the electronic signature in the Cama 2020, that whole process will be electronic end to end. So CAC has been working very hard, really one of our star reformers. We've worked together since 2016. And I'd like to just appeal to private sector to continue to support them. If you have any suggestions when it comes to technology, of course, we're open to getting more suggestions. We've had other companies come to private sector, have offered and indeed come to audit the IT processes, looked at the portal. We know some of the vendors. We've had additional vendors. It's not to say that the process is perfect, but just to say that they're definitely working on it. The RG is here. I'm not saying it because he's here, but he knows the fights that we have. We have the fights. So we have the fights. Even with the vendors, we have the fights.
So you need to remind them about COVID and all the restrictions, because that's actually our major challenge.
That really was the bone of contention. And the worst part was that in the COVID lockdown, people then had a lot of ideas and wanted to incorporate companies, but they couldn't move around. They were themselves locked down. The vendors were locked down. Even trying to get exemption certificates for the vendor staff to move around in FCT and in Lagos, it proved challenging. But I mean, these are some of the things that it was beyond anybody's control, but it was addressed and it was being addressed, and it wasn't for want of trying or want of paying attention or want of wanting to support. CAC is only viable the more the incorporation, the more, so it's in their best interest to make sure the portal is always up. So they were pretty upset with the vendors at the time. Ms. Bashir was mediating and holding on all through, but I think we're making progress. Let me just round up by saying it's a marathon, it's a journey. Please do keep making the complaints and giving the feedback, but let's not make sweeping statements that make it appear like CAC is not competent or cannot do. This is not rocket science. These are people that are globally exposed. They know what it takes. You can hear the RG, you can hear how articulate he is and how on top of it he is on the issues, including what happens in other climes across the world. So let's have confidence in our teams as government, and they can do this work. Let's support them. They will do this work.
Thank you, Dr. Duwale. Thank you. Very well said. Yinka, what's the next question?
There's a question on limited liability partnerships. As they've been conferred with corporate personalities under the
addressed to anybody in particular?
It is not. Under the new act, like companies, does this mean that LLPs will now be liable to pay companies' income tax under the Companies Income Tax Act and to withhold tax on distributions made to their partners?
RG, do you want to give it a try?
Maybe, well, that is actually an FIRS question.
Yeah.
I don't know. Okay. It's the tax authority. It's actually, that question should be for the tax authority. I don't know if you have any taxation.
You are absolutely right.
If I may attempt the question.
Yes, go ahead.
I think that, yes, I think as the RG has said, it's a tax point, and it depends on whether the law as it is right now in relation to taxation is changed. Until it is changed, the partnerships right now are not taxed as corporates. For the LLP, which is the only partnership that becomes an existing legal entity, that position might change. But for the LPs and general partnership, it should remain the same, in which case it's the individual partners that are taxed based on their personal income tax regime.
Thank you, Ozofu. Yinka, what's the next question?
Okay. How much engagement is PEBEC having with agencies at state and local government levels with regards to creating favorable, enabling business environments for SMEs situated within their localities? So
Yinka, I'm sorry, that anybody who is asking that question and stayed would have heard what Dr. Duwale said about.
That's all we do.
about how they've moved from state to state and how they tried to go to one state. There was Lassa fever and all that. So that question has been answered. Let's go to the next question.
Okay. There's several questions, quite a number of questions of where people can access a copy of the act, a soft copy of the act, because people are talking about how they're just hearing about the provisions here, but they've not actually been able to access the act to read it. So is there a place where they can find it?
Very fair point. RG, do we
I
have
don't know
the
whether
act? Do we have the act on your website to be downloaded?
I don't know whether it will be proper to expose something that has not been gazetted. The only valid copy is a copy that has the signature of the president.
Okay.
And until it is gazetted, you cannot expose it.
So when it is gazetted,
But you have a copy already in circulation. People that have copies.
Well, I mean, we have a copy in circulation, but I mean, is there anything wrong with putting something on your website and saying this is because it's been? I believe that the president has signed this. So
maybe I'll come for advice. I'll come for advice.
If you put it on your website and say it's subject to gazetting.
No, he cannot do it. I think the SPL.
Okay.
I was going to, exactly. I was also going to
we can do it.
Yeah. You can
I think you should do it. I think
fine. Okay.
But Casey will wait for the gazetted. Yeah.
Okay, fine. So there will be a copy of the ungazetted law on the NBA SBL website by tomorrow.
Yeah.
Anybody can download it from there. Next question, Ayinka.
And when it's gazetted, the CAC will have a searchable PDF version on their website.
Our website, yes. That's
excellent. Okay. Next question, Ayinka.
The CAC has been given discretionary power to impose fines as it deems fit. What measures have been put in place to ensure that this power is not abused?
Most of these things as I have said, we won't do it alone. We'll involve key stakeholders in coming up with these regulations. All the penalties and fines will be in the regulation. And some of these things are supposed to be a deterrence. We'll look at the nature of the issue, and if it requires a punitive penalty, we'll put a punitive penalty. Where it requires, you need to encourage somebody to comply, you don't need to put a very heavy fine or penalty on him. So, as I have said, all key stakeholders will be involved in coming up with this regulation. So CAC will not be on its own in this matter. Thank you.
Thank you, RG.
Can I just add to what the RG said? Can I just add to what the RG said? And I think that question is actually born of that fear, the trust issues with the regulator. And I think it's important that they understand the rationale in the first place why, those sanctions or penalties have not been in the act. I mean, at some point, we all know that Cama was having, certain figures that were there that didn't make sense. It wasn't in tandem with economic realities. And of course, there was also the concern that how long would it take for us to then amend this law again? So it was important that somebody should have, the opportunity to review this and bring it in line with economic realities. And that means it could go up or it could go down. So it doesn't necessarily have to mean it's going up. Yes.
Totally understood. Next question, Ayinka. Thank you for that, Tony.
Several people have asked whether accreditation of lawyers will be phased out given the new developments.
RG, are you going to stop accrediting us?
No, we'll not. The issue of statutory declaration by legal practitioners is still an option. The promoters have the option to do statement of compliance, or where the lawyer is engaged in the incorporation process, he can submit a statutory declaration. So we're not going to.
RG, you have this process where lawyers are accredited and they have their.
That's what I'm saying. But what we will do is the accreditation remains, but it will be renewable annually for a fee.
RG, we will take that offline.
No, it's better to register. It's better to register a don't know online first, and then take again.
He knows when I say we take it offline. That fee will be 10 naira.
We have to say in front of witnesses. RG, that's a no-no.
No, Madam Tony, you see, we have so many people on the accreditation lists that some have died, some have been barred from practice, some have left the shores of Nigeria. And you have other people using their own numbers to make submission, to submit applications. So if you institute a renewal process, it may not be 1 year, it may be 5 years, 3 years, at least you will be able to sanitize the list of accredited agents.
RG, I don't think that's the cure to that mischief.
No,
If I have been using the accreditation of a dead man, I will renew. I will have the power to renew it as well. Please, next question, Yinka.
Okay, there are several questions regarding Section 839 of Cama. I know that we spent quite a bit on that already, so I don't know if.
No, we dealt with that, in great detail. So let's move on.
We've covered, I think we've covered broadly the areas which the questions touch on.
Okay, excellent. So what do you mean we've dealt with 100 questions, or you bunched them together?
Bunch them together.
Excellent, Yinka. Excellent. So before we take the chairman's closing remarks, I would just take one or two sentences from each of the panelists, just closing sentence, anything you want to throw out there as a closing remark. And I will begin with the RG.
Yes, the assurance, I just want to give this assurance to our stakeholders, particularly lawyers. The CAC, this is the house of lawyers, and they're always welcome. I want them to recognize the peculiar challenges we are facing now with this COVID-19 and the restriction on the number of personnel that are allowed to come to work. That has actually affected our service delivery timelines, but we are working assiduously to have an end-to-end electronic solution that will allow customers to do their transactions without even having to visit CAC. So we'll continue if.
I think we've lost the RG. Okay. Dr. Duwale.
I think the greatest point for me to make is that Cama 2020 has demonstrated to us that collaboration works. I think that it's a model for the entire country, for the entire reform process, particularly with ease of doing business and making sure that our economy can thrive. Stakeholders have worked together in a very collaborative spirit to deliver Cama 2020 amongst other reforms. And we are confident from the PEBEC that with this spirit, we can go further to really achieve a lot for the Nigerian economy. So please, our doors are open. When you have issues, let us know. When you have suggestions, feedback, let us know also. But it's not an adversarial situation. It's not a government thing, because if I start talking about the private sector end, it's just going to be back and forth. It takes two to do whatever. So in summary, collaboration works, and let's just continue to improve our business climate environment so that businesses can thrive. Thank you.
Thank you. Thank you. Thank you so much, Dr. Duwale. Now there.
Oh yeah, just to say that Dr. Duwale took it out right from me. I was going to also celebrate the collaborative framework that produced this process, but I'll just take it a step further, just to assure Nigerians that this same collaborative framework will be put in place to monitor the implementation of these legislations, and also work on the other legislations that are in the works. And we should just trust the process and hope that at the end of the day, we will have an improved business environment and a country that is able to achieve global competitiveness. Thank you very much.
Thank you, Nana. Toyin Bashir.
I mean, so for me, I like to look at it like the journey of moving forward has begun, essentially. A lot of work, a lot of tears, have been incurred on this journey, but we are here. Are we better than where we were 30 years ago? I would say yes. So I think, and then because we're speaking to lawyers, I think we should also utilize the time, because we're all like relearning Cama, right? Let's talk more progressively about the act, just so that we can all start to assimilate the content which we require to do, to render whatever services that we have to our clients generally. And if I may just use this opportunity, moderator, to speak to the omnibus bill, since this is a closing
Please, what is this omnibus bill?
Okay, so right, yeah, so the omnibus bill really is a legislative tool. It's been used in different countries around the world. I mean, so the thinking is, it looked like in a lot of jurisdictions, it takes time to pass the law. Look at what happened with Cama. So what it does is that it pulls, different legislations together for amendment in a single document. So that's why it's omnibus. It covers different areas. So in this case, for Nigeria, what the omnibus bill is seeking to do is put in all those business-related legislations, because it's supposed to be a business facilitation bill. We'll pull everything together, and we've already started having the conversations even before the current speaker, was the speaker. We have been having engagements around this concept because it is new. Although he is very familiar with it, it is new. The whole process of having to get our legislators to understand why are we then pulling these legislations together. But essentially, it's for the good of the nation, just so that we can have this done and the energy pooled for one process. So to do this, I think Dr. Duwale mentioned that inviting comments, from lawyers, and we have been working very closely with the SBL for a very long time. Of course, Leonard Silk has been very cooperative, and we had a period where there were about 40 law firms working, to get all those provisions together and make justifications for them. This was led by Ms. Fola Olusoya, who coordinated that process, and we worked together on that. So yes, the invitation is open now, up till I think about September 4th, because we want to ride.
Where can people get a draft of this bill to read it and make their comment?
So because it's a working draft, it's not available in the public domain yet. We're hoping that at some point when we've made strides, because you see, some of the provisions in Cama were actually embedded in that bill. The idea was, we weren't sure at some point whether, so we had a two-pronged approach. We weren't sure whether, the Cama was going to sail through first or was it omnibus, because His Excellency, the Vice President, was actually committed to that process as well. So now we've had to do another review, and of course there's a Finance Act. There were also provisions in the omnibus bill. So review it, and then this is why we're soliciting for new comments. So I've shared an email with Endurance. Endurance is always very good at getting this sort of information out to the lawyers. So I'm hoping that he would blast that email, and then we hope to receive.
We'll respond accordingly. Yeah. Thank you very much, Tony.
Thank you.
Ozofu, last words.
Yeah, I think I'm going to ride on what Dr. Oduwole said and just say that for me, the Cama journey was really an education in the benefits of collaborativeness, and also demonstrated the willingness of the National Assembly and the President, the executive, to comment and to input. I think we have an impression as a nation, and maybe coming from years of military rule, that the government doesn't listen, they're not interested, they know what they're doing. But this Cama experience really demonstrated that the lawmakers they want input, they want they want to hear you, and that the presidency and the National Assembly came together and worked on this thing, and now we have it. And also I also thought I should say there's a lot of noise about this is wrong and this wasn't done, they're trying to oppress NGOs, etc. But when you filter through the noise, maybe there are 3 or 4 provisions in the Cama that are causing all this noise. So I think on the balance, we have a very good bill. It achieves what it seeks to do, and I think that for any issues that maybe remain issues of concern, let's continue in this spirit of engagement and collaborativeness. And I think the issue of this omnibus bill even makes it encouraging to see maybe we can address some of the issues through that. Thank you.
Thank you. Excellent, Ozofu. It's been an absolute pleasure moderating this session. I've learned more than anybody who has been a participant here. And on that note, I would like to, it's 4:01 p.m. We had tried to push to close this at exactly 4 p.m., but do bear with us. I would just hand over to the chairman of the MBA-SBL for some closing remarks, and then we can all go home.
I really thank you so much for a masterful moderation. You moderated the seminar brilliantly, as always. I actually was thinking that you would give the closing, but thank you for being so generous to give me the platform to do so. I think part of what I'd like to leave with the delegates is that, the stakeholders, particularly those that have been involved in driving the bill to the assent that was done by Mr. President, they haven't had the bill passed and then assented to, and then they've gone into the offices and then you're not seeing them. They're here. I think they should be lauded, they should be commended for being available to answer questions, to being tested with respect to the thinking behind the act that we have, which I think is an outstanding piece of legislation. I was particularly taken by some of the data. I was trying to write them as Inlena was speaking, and I'm going to be contacting him to try and see how we can get that in some kind of a cheat sheet or some kind of a compendium that people can have access to, because we're giving some data regarding, for example, as a result of this legislation, when it becomes operational, that they anticipate that within a year, 2.3 million jobs will be created. Within 2 years, another 2.4, 3 years, 2.9. That normally this kind of legislation will translate into a 5% growth per annum in terms of GDP, 2.5% reduction in terms of poverty. I mean, he gave some very, very striking data. So, with this background, it's really unfortunate that people would even be questioning the benefits of this legislation. I think what it tells me is that the labor of love, the long journey has very well much been worth it. It's been done transparently. The act is geared to yield empirical, qualitative, and measurable results. That is what it's geared to do, and I'm sure by God's grace, that's what we're going to see. I also observed, I went through the list of attendees, and we had a cross-section of attendees, lawyers, non-lawyers, business leaders, young lawyers, very, very, very senior lawyers. We had a whole panoply of people logging in. I was getting messages, people asking if it was being recorded, because some had to jump off at some time and then jump back in. So we'll try and make it available on the SBL website. I cannot, and I really forgive me for taking so much time, I cannot thank the RG enough. This is not the first time that one of us in the past, Ozofu, has had a fireside chat with him. In the past, I believe you've had a Q&A with him at other SBL events. There has never been a time that we've called on him that he has refused or declined. He's always been enthusiastic in coming to our programs. So it shows that we have an RG that is listening, he's business friendly. So I think he ought to be lauded and commended for that.
Thank you, sir.
Absolutely, it's a fact. Dr. Oduwole, what can I say? It's been a delight. It's just been a delight. You've been very effective in what you do. You're just outstanding, and it's been a pleasure. And this is an opportunity for me to also, fortunately, SBL in terms of what we do is a continuum. So Mr. Jamie Day is going to be succeeding me as chairman. So it's very apropos that he's the one actually doing this today. So a lot of these things that we're talking about in terms of omnibus bill and working collaboratively together, you can be rest assured is going to continue. Tony Bashir, like I said before, she struggled Pebek and her private practice when she's able to do that. It's been a labor of love. So she's going to be working collaboratively with us on the omnibus. Ozofu, Ozofu Gemudia, she was our immediate conference planning committee chairperson for the SBL conference. She worked for many, many months. When I say many, many months, it was over a number of years, but many, many months with respect to actually, with the drafting of this piece of legislation. And, I had to give kudos to the people that she reports to in her law firm for making the time and sacrificing to let her be able to do that work. So in there now, NESG, you've been very outstanding. NESG has basically acted as a think tank with respect to getting data from private enterprise, the big business, small business. It's been a very, very collaborative effort. And I can't say enough about the National Assembly. And I think it actually speaks to the quality of people that we have. It would have been easy for us to be talking about just the 9th Assembly, but we have to give credit to the 8th Assembly. And I noticed that both Tony Bashir and Dr. Oduwole did that. We have to give credit to whom it is due. The 8th Assembly worked tirelessly to get us to almost the end zone, and then the 9th Assembly has done that. And of course, finally, we have to give kudos to Mr. President, who, with the encouragement, of course, of our noble Attorney General, Abubakar Malami, SAN, we finally have this bill. So in closing, we've had and nobody has shied away from the, in fact, I've been totally taken by the openness, nobody trying to, weave and bob about whether, there are issues in the bill. Of course, there's some issues and they'll be resolved. So I've gone on and on and on, but it's just because I'm so excited about this. And we thank you all for joining us, and continue watching the SBL space, and have a good evening. Thank you so much.
Thank you, Sheni Adio SN. On that note, I want to thank everybody, and hope we see you next time at another forum. We'll have this from time to time. Have a lovely evening.
Thank you. Thank you.